Hello again, everyone. This is Nathaniel Gibson with my MPA545 Week 6 Alternative Dispute Resolutions Multimedia Discussion Board. As a brief overview of this presentation, I will be taking a look at 4 specific ADRs which are prevalent to this week's discussion, and then I will be exploring those in depth from our textbook, from specific journal articles which cover the ADR, and then one news story for the ADR for mini trial. So in the realm of alternative dispute resolutions, early neutral evaluation, or ENE for short, is a new and innovative way to approach disputes between two parties in the legal system. It involves an initial third-party position, usually somebody who is trained and specialized, like a lawyer, and who is also knowledgeable of the subject matter. There are several benefits that come with conducting an ENE as opposed to going to court. Number one, it's cost effective, and it's easy to help determine what the possible outcome or direction your case might be because of the neutral position of the mediator in this discussion. In this journal article from Wayne Brazil, he summarizes the ADR process and really advocates for it as being something that should be more prevalent in judicial decision making and conflict resolution of modern day because of the fact that it's so efficient and cost effective for different parties. The next ADR is Dispute Resolution Board, and it's an interesting ADR in the fact that this type of conflict resolution selection takes a look at the dispute before and during the actual processing of which in most cases consists of some sort of large-scale civil infrastructure project. And the role of the resolution board within this conflict is to issue a non-binding ruling on issues that arise from contracts on the projects. So what they're useful for is developing a carefully prepared contract before the project begins. Then they are responsible with overseeing the carrying out of the project and the contract to make sure that both parties are acting in good faith in that regard. And then offering, like I said, a non-binding ruling in the case that some sort of conflict may arise and that decision needs to be sorted out rather than going to court instead. For the journal article that I chose here, it takes a look at dispute review boards and their effectiveness in court, especially in convincing developers and other agencies from going to court on these large-scale issues. Moving on now to mini trial. This is also a really cool ADR in that it allows for a very diverse and integrative set of disputes and conflicts within different situations. In fact, it is able to cover most of those situations, and it's typically a dispute between two parties which will last sometimes around 2 to 3 days, depending on the conflict and the willingness of the parties to negotiate. It is mutually voluntary, so both parties have to agree to participate in it, but it does have a lot of benefits because of the fact that they can try to resolve their conflict before going to trial in an actual court and paying all those legal fees. The journal I take a look at comes from the U.S. Army Corps of Engineers, and it shows how mini trial was able to effectively resolve conflict between different government contract claims and really examine the alternatives to the traditional methods that had cost so much in years past. And then also taking a look at the news article from the website Bar and Bench, the Supreme Court, it shows here how they recently sent down a decision where they reiterated that high courts aren't allowed to conduct any mini trials at the stage of deciding an application. And this comes from Section 482 of the Code of Criminal Procedure. Okay, moving on to the final ADR, and that is summary jury trial, or SJT for short. It's a non-binding trial that is meant to occur before or pre-trial a real in-court case, and it's meant to discover and prepare the two parties for what a possible hearing or jury decision could look like. In the journal article that I took a look at, it really just summarizes the benefits of having a summary jury trial, because of the fact that approaching this conflict beforehand can really help to resolve the issue and prevent the courts from being bogged down by all these different issues that could have been simplified or resolved in a simpler, easier to understand format. Well, that brings us to the conclusion for my discussion board of the various ADRs for this week. I appreciate you taking a look at my video this week, and I look forward to discussing these ADR concepts further and getting to learn from each other.